You are on bond for murder, and you've now picked up an assault case.
Whoa, hold on. Did you catch that? This person is already out on bond for murder, and now they've picked up an assault charge? That's a massive red flag in the legal world, because multiple violations can mean the judge won't show any mercy this time. What do you think? Should bond even be allowed in this situation?
Weapon call. The complaining witness stated she is part of the nursing staff and that the defendant has been asked to leave on multiple occasions and refuses to do so. The complaining witness stated that the defendant was attempting to get her grandfather to sign over power of attorney to her, but the staff would not allow this due to the grandfather being diagnosed with dementia. The complaining witness stated that the defendant used force on the complaining witness to get her to leave the grandfather's room. The complaining witness states that the defendant put her hands on the complaining witness's face and pushed it back. The defendant was positively identified by the complaining witness and her Texas ID number.
You say that there was any pain? She pushed in the face. This is an assault, right? There has to be some kind of injury or pain.
And she did state that she felt pain in the episode.
Okay. Ms. Taylor, I'm going to find that there's sufficient probable cause to go forward with the case. Now, you're saying there's a bond violation in this case?
Yes, Judge. It's in the...
Michael, have you seen this? And how did you already get appointed to this case?
Your Honor, I was appointed sometime very recently on this case. I received a text. I don't know what day it was, but I received
it looks like it was the 29th, which was Tuesday. But how was he appointed a lawyer?
I'm thinking when she was in the holdover.
No. How is she? I mean, I don't understand. Well, regardless, I guess I'm glad that you're appointed, because right now she's got bond violations. She was ordered by the magistrate.
I wasn't aware of that, Judge.
I'm sorry?
I wasn't aware of a BVR in this case. I actually have another BVR today before the court.
I know that. Yeah, we got you. We'll deal with that one next, but you're on bond for murder. You were ordered by the magistrate to have a GPS monitor. You have violated those conditions.
And there it is, bond revoked. That means the judge just sent her straight back to jail. Why? Because when you're on bond, you're basically promising the court you'll behave. Violating those terms? That's like breaking a second promise, and judges hate that. Do you agree with the judge's decision here, or should she have gotten another chance?
And she could not have been out of jail more than a day, 2 at the most. Would the court allow her to leave right now to get the device?
No. Did she not get the device?
There was a conflict. That's why the ADR was submitted. Felony. So the magistrate ordered bond conditions, but the curfew times were not aligning with the felony condition.
So what? I mean, you still have to abide by the conditions. I mean, what did they say the conditions were?
I have the whole unit right there.
I'm not asking you to say anything, Ms. Taylor. The only thing I want is I want my city protected. You're on bond for this serious case, and now you pick up an assault. I mean, you were ordered to have certain conditions. You must abide by these conditions.
And Your Honor,
she received conditions of bond on April 28, 2025 that ordered a GPS device with a curfew of 7 p.m. to 7 a.m. On May 1st, she had an unapproved enter at 7:52 p.m. and then left again at 8:51 until basically 9 o'clock at night.
Yes, Judge. And on the felony conditions, I'm looking at them right now. Her curfew is from 12 a.m. to 6 a.m. So that's where it's conflicting. So the magistrate ordered from 7 p.m. to 7 a.m. and on felony, her curfew was 12 a.m. to 6 a.m.
I mean, she still has to follow conditions, right? There may be conflicting, but you abide by the conditions, and then you come to court and you ask to, do something or maybe make them align, but you just don't do whatever you want to do and think, okay, nothing's going to happen. You're on bond for 2 serious cases.
Your Honor, if I may again.
Sure.
This is a brand new case. Could the court admonish her because the amount of time, I understand that.
Michael, she's on bond for murder. She's lucky to even have a bond, and now she picks up an assault. She's ordered to have a curfew, and she's just doing whatever the hell she wants to do.
In this case, Judge, that's before your court. This is a brand new case, and this is her first time having any issues while on your bond, Judge. Would the court be willing to admonish her not to leave her home even for short periods of time?
I don't know, Mikey. I don't know.
And my assumption is we're going to reach out to Melanie. My assumption is there would be BRL for that too. So I don't know what thought her was.
I don't know, Michael. I'm going to stew on it for a while. You
Yes,
want to talk about your other BVR? Or wait, hold on a second. Sorry, let me just finish with the arraignments. Give me 2 seconds, and then we're almost
no
done.
problem, Judge.
Good morning, Mr. Randolph.
Good morning.
So you're charged with assault and causing bodily injury. You're facing up to a year in jail and our $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. All right.
The judge. Judge on.
We're doing here. There's no reason for you to be looking out there. We're going to do probable cause. We have to find out what happened with the case.
Judge, on April 23rd, 2025, an officer dispatched an assault call and made contact with the complaining witness, and the defendant. The complaining witness stated that he saw the defendant talking to and following a witness, and the witness then started to run away and observed the defendant to chase after the witness. The complaining witness then got in between the defendant and the complaining witness, and the defendant then struck the complaining witness with a closed fist. The complaining witness said he felt pain, and they grabbed the defendant and they proceeded to grapple until security arrived. The witness stated that she did not know the defendant and that her and her friend walked past the defendant on the street. The defendant then began to verbally harass them and started to get verbally aggressive. She asked the defendant to leave them alone, and the defendant continued to refuse to do so. And that she began to walk away and to try and get away from the defendant, but got stuck at the intersection crosswalk. Then corroborated the facts that the complaining witness provided about getting in between the two of them.
Mr. Randolph, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you understand? I'm ordering you also now not to be in possession of weapons, not to have any contact with the complaining witness, and not to go to this part of the street. Do you understand?
Yeah.
Don't be a danger to my city, man. I'm not asking for much.
I'm not in danger. I do never know these people, Your Honor. I need a public defender.
I'll give you one. But I'm telling you now, Mr. Randolph, don't be a danger to my city.
I was never in danger. Just I don't intend to be in danger either.
All I want my streets safe.
It was in danger to me, and that's why I'm showing up today.
I'm going to protect my streets at all costs. You
You
understand?
protect me from these kind of people.
I'm going to have you go to Victoria, sign a reset. After that,
I don't need a public defending office, your judge or
I already
lawyer.
told you I was going to give you one. Just really.
I'm really scared for my life because I just did 4 years and I'm going through the same thing again in your courtroom when I did good, and I'm going through all the facilities. There was never in a harm's way standing 100 feet away from these people or 200 feet. I was never 100 feet within there.
No. Exercise.
And I'm running from these people.
You're going to say something that hurts your case. Just stop.
Yes, sir.
I'm not asking you to say anything. I just want
to also be safe in your community also.
Don't use any dope. Don't use any alcohol.
Never was. I was sober that day. I was sober as can be. No drugs, nothing. enjoying a beautiful day for my mama's funeral. I know no rules. I don't know these people.
Listen, I'm gonna have you sign a reset. I'm gonna have you take your seat in the jury. Yo, I'm not talking to you. Once you sign the reset, just take your seat in the jury box. I'm gonna find your lawyer, but we need you to sign conditions. Don't leave until you sign the bond conditions.
Yeah.
Come on. You are on bond for criminal mischief. You've now picked up a new case. You now stand charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Judge. On April 26, 2025, a law enforcement officer is on patrol and observed a motor vehicle run a red light and make a U-turn, nearly striking another vehicle in Harris County, Texas. Law enforcement officer observed the motor vehicle drive onto the curve of Richmond Avenue and initiated a traffic stop. The defendant passed multiple open parking lots and continued to drive. The defendant eventually pulled into a business park with him. The law enforcement officer contacted the defendant and observed him to be eating fried chicken. The law enforcement officer asked the defendant why he didn't lower the window, and the defendant stated he didn't have anything and continued to eat. The law enforcement officer observed the defendant did not have a driver's license and was incoherent when asked to provide his name and date of birth. The law enforcement eventually identified the defendant by name and date of birth. The defendant continued to state, "I don't have anything when questioned about his whereabouts," and standardized sobriety tests were conducted. The officer observed 2 out of 6 clues in the HGN, 5 out of 8 on the walk and turn, and 0 out of 4 on the rolling stand. Due to the defendant, 0 out of 4 on the rolling stand due to the defendant being unable to perform the test. The law enforcement officer noted that on the walk and turn, the defendant did not turn around. He stayed still for approximately 30 seconds. The law enforcement officer explained the one-leg stand, and after the instructions, the defendant began performing the walk. This occurrence happened again after the law enforcement officer tried to explain the one-leg stand another time. The law enforcement officer observed 2 unopened 6-packs of alcoholic beverages that were cold to the touch, and observed an empty fuzzball and a 24-ounce can of beer and an empty twisted tea of alcoholic beverage. The defendant refused both breath and blood. A blood warrant was signed and executed.
Mr. Juarez, I'm going to find that there's enough probable cause to go forward with your case. You said he doesn't have a license, right?
Yes. There's a number here. I'm not unsure if that meant that he did not have the license at the time.
I don't mind running it, please.
Yes, Judge. Your Honor, he does have an eligible driver's license.
I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I've ordered you not to pick up any new cases, not to violate conditions of bond, and you have repeatedly done that. As a result, I'm now revoking your bond on the first case, and you will go to jail today. And I'm going to tell you, you violate conditions again, I'm going to make the bond so high your head will be spinning. Do you understand? You're not to consume alcohol or illegal drugs, and I will put a scram on your ankle so I know that you're not consuming. Do you understand?
Your Honor, if I may,
Yes, sir.
on the first case, the court previously was testing Mr. Juarez 2 times a week, and he was doing pretty good on that for an extended period of time. In lieu of revoking his bond, would the court consider going back to bi-weekly testing?
Yeah. He picked up a serious case. He has alcohol in the car. I mean, he's allegedly consuming while he's driving, you know? I would figure that it's damn elementary that you're not to have alcohol in the car while you are driving. And there are multiple open containers, cold to the touch. Now, I have to show you that we mean business. And me letting you go again when you have multiple violations, it's not going to happen. You go to jail. I don't know what we're going to do when he bonds out, Michael, as far as testing now. I don't know. But
I understand, Judge.
I'm going to order him not to drive as well. I mean, he's got alcohol in the... No, it's not going to happen. Good morning.
Judge, I'm approaching on Victor Jesus Rauda Lopez. And he's got a bond violation reported on him.
Page 10.
Is he here?
He's here, Judge. He's in the jury box.
Speak English?
Yes, he does.
Come up. Come up.
Answer yes or no, sir.
Did you get your GPS device?
Oh, yeah.
Okay. I'm revoking your bond. I ordered you to get a GPS device. You didn't get it. Okay. Those are you. Sorry, Maria. All right. We're going to keep you. The bond right now is, God, it's 5,000 now.
I already paid the half.
6,001. Yeah, you raised it up 1,001.
6,000.
It's 5,000 now.
Right.
So I'll just do 6,001.
Okay, Judge. 6,000.
So if he bonds out.
Yes, Judge.
All right. Good morning, Mr. Ayler. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. It looks like you're also charged with unlawful carrying of a weapon. On that one, you're facing up to a year and or a $4,000 fine. Okay.
Thank you, Your Honor. On April 27, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle traveling 50 miles per hour in a 30 mile per hour zone via radar and failed to signal at a right turn. A traffic stop was initiated, and upon contact with the defendant, the law enforcement officer observed a handgun on the rear right passenger floorboard, unholstered, and later confirmed to be loaded. Law enforcement officer observed glossy eyes, strong odor of alcoholic beverage, and slurred speech from the defendant. The defendant admitted to consuming 3 alcoholic beverages. Standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, a 2 out of 8 on the walk and turn, and a 2 out of 4 on the one-leg stand. The defendant consented to provide a breath and blew a .136 and a .141.
Okay. Any prior DWIs?
Yes, Your Honor, out of a different county.
Did it open?
No, Your Honor. It was closed in 2014 with 12 months of probation.
Can you run a full NCIC to see how many there are?
Yes, Judge.
Mr. Ayler, I'm going to find that there's sufficient probable cause to go forward with the case. Also, if you can run his license, please. I'm now placing a restriction on you, Mr. Ayler. You are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I will revoke the bond, put you in jail. No more PR bonds. Likewise, you're ordered not to consume alcohol or illegal drugs. You will be randomly tested. I'm sending notice to DPS in Austin. Every single officer in the state will know that if you're driving a vehicle and it doesn't have an interlock, you will be arrested and put into jail. Do you understand?
Judge, it's just the one previous DWI.
Okay, license, did you say?
License.
You're also not allowed to drive unless you have a valid license and liability insurance in your name as well. That is a part of your bond conditions. For now, I'm going to have to go to Victoria, sign a reset. You will eventually get with Roxanne for your bond conditions, and after that, you'll be free to go.
It is audible.
Great. Okay, come on. Mr. Bustamante, I know that there are 2 sides to the story. I get it, right? That's why we have trials. But in the interim, we ask you to do several things. And when you don't, there are serious consequences. Number 1, we ask you to show up. On your first case, you failed to appear just in and of itself, and we had to issue a warrant for your failure. We issued bond conditions on that as well. Those conditions were also broken. You've now picked up a new case. I want you to understand something and listen and hear me clearly. Mr. Bustamante, I want you to listen and I want you to hear me clearly, because what I'm doing now is I'm putting orders of protection on both of your cases. And if you violate these, you are looking at 2 more very serious violation of a protective order case. That, in and of itself, is the capital murder of.
Did you hear that? The judge just called a protective order the capital murder of misdemeanors. That's not just dramatic. It means if this defendant violates it, things can escalate fast. Protective orders are serious business. What's your take? Should violating one lead to an immediate no bond hold?
Witnesses in these cases. I don't care if they're relation. I don't care if there's no relation. I don't care who they are. Do not have contact. And when I mean no contact, I mean no contact of any kind. No phone calls, text messages, social media, emails, Snapchat, whatever, maybe smoke signals. No means no.
It's problem, Your Honor. It's not a problem.
So this is now an order that identifies both Bustamantes as protected individuals. You cannot communicate with them. You cannot commit an assault, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, communicate with a third party to try to communicate with them. You cannot be in possession of a weapon or go within 200 feet of where they live or where they work.
I understand, Your Honor. I got 7 kids. And those are not the oldest ones. I'm a good dad.
Don't talk to these 2.
I understand, Your Honor.
This order only applies to these 2. Don't use the other kids to try to have contact with these. If you do,
we all live together. Right.
Now you don't.
Right. I'll go to Mom's house.
Best go somewhere else because they're going to inform those kids now that you're not supposed to be there or have contact with.
That's not a problem, Your Honor.
All right.
The first one, my daughter, she doesn't live here. She ran away with her husband. You know, whenever she called the cops, she wasn't even at the house.
I don't.
Don't go
You have contact with them. I'm not asking you much. You've already picked up 2 cases. You pick up a third, I'm going to blow a gasket.
That's tough. You got it.
State, is there anything else?
Yes, Your Honor. There are allegations of drug use too. We would ask for rating your analysis.
Okay. You're not to use alcohol, illegal drugs. I'm going to randomly test you. If I find that you're using, likewise, I'm going to revoke these bonds. I will put you back in. As it stands now, you are a flight risk. I'm not going to give you a PR bond. So what'll happen now is we're going to put you back. I've got your bond set. If you have someone that posts your bond, then you must abide by these conditions.
My daughter, my daughter.
I've given you a lawyer. You need to talk to the lawyer. You have the right to remain silent. Everything you say, they're going to sit there and they're going to type it to use it to prove your guilt. Just don't say anything. I'm telling you what the expectation is. So if you do get out, you don't pick up a third case.
I have a question.
What's the question, Matching?
The lawyer.
Okay. So okay.
Okay.
We're good, Judge.
You good? Okay. All right, Mr. Bustamante, you know what's expected of you from now on. That's it.
Thank you.
So we need him to sign conditions with Roxanne whenever.